Good evening, everybody. My name is Stephen Brown, and along with me is Rahul Reddy. I'm a senior associate at Reddy Neumann PC here in Houston, Texas. Rahul, of course, one of our named partners. We conduct this live stream on our various social media platforms every Tuesday at 5 p.m. Central Time. A few topics that we're going to discuss today, and as always, we're happy to take your questions in the various chat forms. A few topics that we're going to discuss today is organizations that are guaranteeing green cards within 4 months. Are these legitimate or not? Whether or not you can conduct business activity as the owner and operator of a business on an H-4, H-1B, H-4, and F visa. Uh, Changing jobs while your adjustment of status is still pending. Various things to consider with that. And any tricks to avoid the per country limit with EB green cards. Excuse me, Rahul. You've seen them. I've seen them. Organizations that go around saying we're going to get you your green card in 4 months, guaranteed. What are your thoughts?
Oh yeah, you can. You can go to some of these places for $250. They give it. This is exactly a USCIS director has told me that there are agencies that you go in some of these bazaars, they'll make it and give it to you.
Oh,
So please be very careful, guys. When somebody is telling you information that looks to be fraud, that acts like fraud, and that sounds like fraud, most probably it will be a fraud. When we walked into, and me and Steven were also in a couple of meetings where people walk to us, 14-year-old kids. I mean, these kids are just advertising for whoever is paying them $10 or $12 per hour and handing over the things to us saying that, oh, guaranteed EAD, guaranteed green card in such and such less period of time. Now, we want you to be very careful of those things, especially they ask you to put a lot of money, which is, it's not guaranteed at all. Nothing is guaranteed. So be very wise, be very careful when you want to trust any of those things. What about those people, Stephen? They file political asylum when they're not even eligible. They get the employment authorization and they come and show me, I got the employment authorization. You said I can't get it. What do you feel about them?
yeah. I mean, look, we've seen it. The political asylum, they give that EAD with a very bare bones review. I mean, do you have a case? Now it takes a long time to get that EAD, but if there's a determination that you even have a case, they're going to give you the green card, whether or not you actually have a legitimate claim to political asylum or not.
So is it worth for them to take this chance?
I'd be very cautious. A decision of fraud or willful misrepresentation through immigration can result in a permanent bar from the country, and it's something you need to really try to avoid.
You are signing a document prepared by these agents or immigration people, though, that are taking the money of you and making statements on behalf of you. But you will be responsible for these statements. If any of these statements are wrong or misinformation that you have provided, you will be barred for mispresentation forever. You see a lot of these people put in deportation proceedings and back. Those people disappear. I mean, these are agencies that come up, will stay for a couple of years, will take money, a lot of money, and then they disappear. So getting that temporary EAD with all the fraud statement may not be that hard, but it is not advisable. We tell people not to indulge into these activities, not to even go into pursue those kind of actions. Please stay away from these people and have a second or third consultation. If somebody is telling you something is easily available and nobody else is offering, most probably there's some deceit in there. Please be very careful before you sign any document, you submit any document, though.
Yeah, definitely hard to make guarantees with the immigration side.
Now, Stephen, what are the implications, though, with regards to people who are in H-1B, H-4, and F-1? Can they own the stocks in the United States?
Yeah, absolutely. I mean, if you're just a passive investor, you're on your Robinhood app buying up, Apple, Tesla stock. No issues with investing in stock.
Can I trade and make profits also?
Absolutely, because you're not involved.
What if I make one trade or two trades a day? Is that something illegal?
Nope, don't think it is.
Okay. So what is that I cannot do? I mean, can I own a restaurant, though? What do you say about it?
Yeah, I think if you own the restaurant, you hire a business manager that's going to run it, and you say, hey Rahul, you're going to run my restaurant, and you're not involved in the day-to-day operations, you're not involved in the business side of it. I think that's fine. Being a passive investor.
Yeah, but when I see my own community people, Stephen, I see that they get a little bit different than just hiring there. They'll go taste it, they'll do the things. So what my belief is that if Somebody else is actively managing. You are just investing as a partner, and you are not involved in any management, in signing the documents, hiring people, doing anything. It may be okay. I would still definitely consult a lawyer. In the case of stock ownership, trading, and all those things, oh, you're good. You don't have to worry about it. You can do whatever you want to in the stocks. Absolutely no problem with it. But when it comes to the restaurant ownership, consulting company ownerships, or any other LLC where there is any activity involved in it, and you may be there in the meetings of those things, definitely I strongly recommend that you consider a lawyer.
Now, let me ask you, all these situations that comes up, people that are staying at home with the kids, and they say, "Hey, you can make money just staying home, and you don't have a work authorization. You're just on H-4. You don't have EAD." And they say, "Hey, you can sell my Mary Kay products."
You mean to say they are in H-4 and don't have any EAD?
Correct.
Oh, like Mary Kay products, Amway products,
Yeah.
where they sell, they get some commissions. That is definitely considered as working in United States. That will be a violation because the person does not have an employment authorization. Now, even if they are in H-1B, Stephen, though, they have an employment authorization to work for their particular company. Let's say it is AT&T. So they're only supposed to work for AT&T. So if they sell the product from Amway or from Mary Kay or some of these financial organizations that they sell and make commissions, it's perfectly not, it is definitely not allowed, Stephen. It's not allowed. Now, having said that, though, if people are involved in a religious organization, they go to a temple and they volunteer, they become a committee member in a cultural organizations, like language association organization, they're involved and they work there. They're not getting any money returned there. They do not expect to get any money there. That is perfectly okay. uh, Going to Red Cross, going to planting the trees. These kind of activities, voluntary activities, are perfectly fine. But when it is a Mary Kay, when it is a Amway, when it is this financial transaction, when there is where you're getting a monetary thing, though, you are working there and you do not have the work authorization for that. So you should not be doing any of those activities, dear.
Yeah, I think the best way it's been described to me, the distinguishment between volunteer and work is it something that would otherwise be paid? And if it's, like Rahul said, go to a volunteer at the library, that's, restocking books wouldn't otherwise be paid, then that's a volunteer position. But if it's saying, "Hey, I'm going to go work on this software just for the, fun of it," probably otherwise be paid.
Um, we want to also discuss about changing jobs and adjustment of status. What are the things to be considered, though? People are paranoid, Stephen. They're saying, "Oh, I'm moving from software engineer to software developer." Is that going to be a problem?
No, if it's in the same job field, and that's a very broad category, right, with USCIS for this. If you're in the same job classification, you shouldn't have a problem. So, Rahul, I mean, going from a Java developer to an SAP developer, I think is fine. But if you're going from Java developer to lawyer, I think that's not going to be in the same job field.
In my experience of past, from the time the AC-21 has been introduced in somewhere in 2022, 2002 to right now, in 20 years though, I have only seen one denial, Stephen, on the people who moved from one job to another job and used the AC-21. I've only seen one denial, and that was because the person was on a the person was on a the person was on a as a software engineer in the adjustment of status, and later on he applied for a liquor license, indicating the only job he does is a restaurant manager. Though we were unable to defend and get his green card approved, though that got denied. That's the only thing. Most of the people that I think so, when you move up a ladder in your job, it's perfectly okay. It's perfectly okay if you change the MSA location. I mean, that's perfectly okay, as long as you're working in a similar profession. And the salary doesn't have to be the same. If it's somewhere nearby, ballpark figure, you will be in a good shape. Especially when the labor certification has been filed, it may be 60, 70,000. Now that was about 10 years ago, and now it's a different story. And if it has gone a double fold, also, I haven't seen any problem anywhere. But it's always good to check if it is several folds increase. It's always good to check with a lawyer. But as such, I have not personally seen any denials. Anything else to discuss on this topic?
No, changing the job is 180 days, right? 485 got to be passed.
That's right.
I-140.
Right. One thing you said is 180 days. you can change the job after 485 has been filed after 180 days. But I also point out, though, even though this is not a legal aspect, though, but this is a very practical aspect people need to consider. If the underlying I-140, that means that if they have downgraded to EB2 to EB3, if the I-140 is not approved, we strongly recommend you do not change the job. Even though there are ways to get around it, even though there are ways you can go to court and reverse it, because the rule says that the I-140 must be approvable at the time of filing, though. So if after 180 days, if this guy leaves, if the company withdraws, though, if you go to the federal court, you can get that decision overturned. And then who else to say? I mean, Stephen Brown is the litigation director in our office. Yes, you can hire him, you can take him, and he will fight your case until your last blood loss. I mean, that's what we are. But we try to avoid it. we try to avoid. Please, if your I-140 is not approved, we strongly recommend do not change the jobs. Wait until the I-140 is approved. It's not what now. If you do want to consider changing the job before the I-140 approved, even though if it's 180 days, I would strongly recommend to consider Stephen Brown or me and consult me and make sure that, what are the complications, how much expenditure is going to be, what are the things that we need to do to get these things, to get the 485 approved. So it's very important for you to understand that.
So Rahul, kind of dovetailing from that topic, while my AOS is pending, lots of time to get the green card, get the 485 approved. Obviously with that, retrogression, that's longer. AOS versus maintaining your AOS EAD versus maintaining your non-immigrant visa, your H-1B. What are your thoughts on that?
I personally, Stephen, when I was on H-4 visa, I had an EAD. I let my H-4 go. So what can I tell the other people? Just because I'm going to make money, you're going to make money, can I tell lies? That's up to them.
Yeah, I don't see any reason. I mean, you can't be on that EAD if your 485 is pending the
right. There are certain circumstances, though, I would, especially if the I-140 is not approved, Stephen, though, I would wait not using the EAD. That's one thing, because I want the I-140 to be approved. Another thing that I will be very careful, Stephen, is that if the children are about to get aged, though, before, I mean, when the age means when the children are about to become 21, and their age is not locked in the CSPA age, that is Child Service Protective Act, I would rather want to consult a lawyer before I move on to EAD. But for those people who already, who don't have any teenage kids, who don't have any, and who don't have any problems with the I-140, typically my estimate is that if you go on an EAD, you are at a 0.5 risk. That means that every 200 cases, there is one case that may be a little bit risk, though. But when you maintain H-1B and you maintain the EAD, I would give a 7% risk. You just got an email. I don't know if you checked your email. Yeah. I got the CC of that email that you're a lawyer, and they were pointing out 100 questions. How many questions were there?
It was at least 30.
It was an FDNS question where the person is maintaining the H-1B, and it's FDNS. There was like 30 questions asked and all those things. Those are the things you will avoid. You most probably avoid if you only maintain EAD. You don't have to go for stamping at all if you maintain the EAD and advance parole. The filing fees, do you know how much is the filing fees for EAD and advance parole, Stephen? Zero. Right. Zero. We don't need inclined letter. We don't need anything. We don't need filing fees.
Well, the only adjudicative factor is your 485 pending.
Oh,
the analysis is...
No, there's one other thing, though. Whether you sign the 765 form and you have included the passport size pictures. Three things are there, you're it. You get the EAD approval. And the good part, Stephen, is that even if the EAD is not approved, though, if you file the extension, you're allowed to work for 180 days, within 180 days after your EAD expires. So which is actually a very good thing also for people to consider.
What about if you use your EAD? You're now on your EAD, you've gotten rid of your non-immigrant status, and now I want to downgrade from EB2 to EB3 or upgrade EB3 to EB2.
Yeah, there are two things if you want to downgrade or upgrade, though, Stephen. One is called interfiling. That means that you just send a notification to the USCIS saying that, look, I filed a 485 under EB3, now I want to consider under EB2. For that, even if you use the EAD, you can do the interfiling. Absolutely no problem with it. Now, if you want to refile the entire application, though, okay, that means the refile, filing fees, everything new, though. At that point of time, you have to maintain the non-immigrant status. If you're in adjustment of status, you cannot file one more adjustment of change of status, though. That's definitely a deficiency, right, if you're considering using the EAD. And I also tell that people that we have been through Trump era, and who knows, Trump era might come again. Hopefully not, but you never know. So we have seen a lot of denials. H-1Bs were getting only approved 6 months, 1 year. There was so many RFPs, there were so many denials. There was not even a single day in our office where we have not, every single day we used to see a denial. Now it's like, oh, I don't know, it's been long that I've seen a denial. So people are under the assumption they're very scared of the immigration, especially going through the 2016 to 2020. And they're very scared and they want to do all those things. But I have to tell you one thing though, even at the Trump era period though, at that time, people who are in adjustment of status, for them to extend the EAD and advance parole has been the same. No filing fees, just the 485 pending, sign the document and the passport size pictures. That's it. They got all of their thing approved, no problem. So maintaining the EAD is quite far simpler, even in the Trump era than compared to H-1Bs. It's way, way simpler though.
Yeah, processing times are bad, but getting it's easy.
Yeah, but even processing times, you have the 6 months extension.
And you can apply 6 months in advance. So you get like a year.
Yeah, you have a year, and then typically it gets approved anywhere. But it used to be 3 to 4 months. Now it's taking about 6 to 7 months right now to get a renewal application approved.
Rahul, one of the other topics I wanted to address, obviously, the primary folks that bear the burden with the visa bulletin, with the green card backlog, are Indian and Chinese. Any ways around that?
Very tough, the only thing that is available is that if your spouse is born in a different country, you can consider something called cross-country chargeability. For example, if you're born in India and let's say your wife is born in United Arab Emirates, you can be counted towards the United Arab Emirates. It's called cross-country chargeability, though. Even though your wife may not have a UAE citizenship, even if she is born there, you will be considered for the cross-country chargeability. You need to explore that. Stephen, can I go and buy a passport from some country and then go to the cross-country chargeability?
No. To qualify for the cross-country chargeability, it's based off of where you or your derivative spouse were born. So even if you get citizenship in another country, Canada right now has been very attractive. Here in your 30s, that's not going to work for the cross-country chargeability.
When I say buy a citizenship passport, there are some countries, guys. I mean, you can just buy the passport. You just pay some money, invest in a house or something. They'll give a passport. It's perfectly legal, though. But unfortunately, they don't come into the different quota since they are born as an Indian national. For the purpose of the immigration, it is the country of birth that counts. For the purpose of the non-immigration visas, for example, TN visas, for example, for example, e-visas, it is the passport that you can use, though. But for the immigration visas, it's the country of birth. So you cannot get away once you're born in India. You are born in India. We cannot get away from that. Let's go to question and answers. Stephen, unless you have something?
No, let's do that.
People are asking questions with regards to the 180-day travel requirement to Canada Canada and Mexico to extend their H-4. Can you explain that process?
Yeah, so obviously with our settlement insured, we now have the automatic EAD extension for H-4 and L-2 spouses for up to 180 days, as long as they have a valid I-94 that's expiring beyond the EAD expiration, and that they have timely filed for the EAD. And with this, we've seen a lot of folks where the primary spouse's H-1 or L-1 gets approved, and then they travel to Canada or Mexico to get the new I-94. And that's perfectly fine. If you are able to go to Canada or Mexico, and obviously we're not lawyers for the Canadian or Mexican immigration system, but as long as you're able to travel to Canada or Mexico and come back, we do recommend that you do this while your I-94 is still valid. While we are seeing some positive trends of them giving the expanded extended I-94 while the after the H-1B has been approved. There's a small possibility of them only giving it to the I-94 expiration for the H-4. So we recommend going before your I-94 expires. That way, your worst case scenario is you're back in the same situation you are now.
And we have seen a very good number of people getting their I-94 extended, H-4 I-94 extended. We recommend people flying and staying 2 nights. And we strongly recommend to take your spouse also, who is the main primary H-1B applicant. People ask the question, hey, my H-1B is not stamped in the passport, my H-4 is not stamped in the passport. But that's the reason we're telling you to go to Mexico or Canada, though. Otherwise, it could be also India. But going to Canada and Mexico is the best thing. Now, this is a temporary solution for only 6 months. What's going on this H4 EAD delay litigation, the class action suit?
Yeah.
What's going on?
So
just for the people to know that Stephen Brown is one of the lawyers who's litigating the class action suit for the H4 that will be applicable to all the people and the benefits that are going to come from it.
Yeah, so our Edacuni class action suit up in Seattle, we've had fully briefed on motions for summary judgment. Both parties have briefed. We got a new judge assigned right before the holidays. And she had a conflict check that she just needed to look through that I had not seen any issues with based off the previous law firm she's with. My hope is that now that a new judge has been assigned, she's going to start working on a decision or holding a hearing. Obviously, unfortunately, we can't control how long the judiciary takes. But everything's fully briefed, and we keep providing updates to the court as we see it. And again, we have our motion for summary judgment as well as our motion for class certification, fully briefed, ready for the judge to rule on.
Surabhi has this question, though, with regards to, from the desk of the lawyer in the coming months, do you think EB2 will stop or retrogress due to the current interfilings and refilings? Good question, Surabhi. One thing I can tell you, Surabhi, is that the number of green cards that are getting adjudicated every month has gone up very, very significantly. If I have to consider the first quarter of the last year, the quarter starts for us on October 1st, guys, unlike the rest of the people. So if you look into from October 1st of 2020, October 1st of 2020 to December of 2020, December 31st of 2020, and now when I see the October 1st of 2021 to December, the amount of green cards that were approved from a desk of an immigration lawyers have gone up. And in the month of January, Surabhi, for some reason though, it has gone up very high. In fact, we have updated our data on immigration about a week ago. From week ago, we have not updated. We're going to update it maybe tomorrow. I want you to guys watch the immigrationgirl.com. Just yesterday and day before yesterday, we got so many number of green cards from this particular lawyer's desk. It's unbelievable the amount of green cards that we got in one particular week, though. So if I were to base all these things, Surabhi, one thing is for sure, they are adjudicating at a faster pace. However, Surabhi, the total amount of 485 applications pending with them is not that high. It's about maybe between 200 and it was about 280,000 at the beginning of the year. So they haven't released the next data yet, though. So if they keep on adjudicating at this level, though, we may be expecting the amount of green cards that will be used this year. We have about 280 to 290,000 green cards available. They may be able to use a good number of those 280 to 290,000 green cards. So, which is a good news. If that happens, though, we may expect things to move forward, EB2 and EB3 to move forward. That is what we can expect if they are adjudicated. Now, depending on the speed of the adjudication, the things will move. Because if they cannot adjudicate it, why are we filing these cases to be considered in future? Because they're going to hold those cases. So the more they adjudicate the cases, the more we will see the forward movement of the cases, because the amount of green cards that are available this year were never available to the employment-based in the lifetime of the employment-based immigration history that I know of, which is 25 years. No, we have not seen that. those many number of green cards available for the employment base. So it's going to be good news coming forward, hopefully so. The letters that you have been writing to the congressmen, to the senators, to the USCIS directors has been working. They have issued a Twitter. They have made employment based as a priority. If anybody have not written, please, there's a draft written. There's a link we have provided. We want you to use that link to write the letter to the congressman.
Raul, this is a question we see quite a bit. How do you get notified if your CISPA age locks in, and if you're applying for 485? How do you prove it? Is there a form you got to fill out to show the math on it?
No, Stephen, there is nothing like a form. If your I-140, the I-140 has to be approved. The 485 must have been filed. 485 must have been filed. I-140 is approved, and the child is under 21. Okay, under 21, and the amount of time that is deducted, the amount of I-140 time will be deducted from the age. If I-140 has been filed, I-140 has been approved, 485 has been filed, child is under 21 and CSP, they are locked. There is no certificate, and of course, final action dates is current. Sorry, thank you for reminding. The final action dates are current. 4 things: I-140 approved, 485 filed, CSPA age is under 21, final action date is current. That is it. There is no evidence is required. There is no document. There is no certificate that is required. If you can print all these things, which is easy, I-140, 485 receipt notice, you already have it. Birth certificate is already there. Final action date, it's there online. You print all of them. That is an evidence that will lock the age of the case.
So let me ask you, the final action date has to be current. What if the final action date retrogresses? So I lock in today, and then 4 months from now, it retrogresses.
If you are locked in one day, okay, then you're locked in. That's it. If the final action date moves back, the kid is saved. The kid will get the green card. The only thing is that the kid cannot get married.
Right.
That's the only condition.
Child.
Yes. But one thing, Pujita and other people, sorry, not Pujita, one thing, Sweet Elodie, that you need to notify is that the final action date has to be current, and the I-140 must also be approved, though. If the I-140 is not approved, you are not locked in. Radha, we has option. What are the options if I get a green card while I'm in India? Good question. If you have an advance parole approved, I'm assuming that this is an employment-based green card. If you have an advance parole approved, Radha, we are having no problem in people traveling in advance parole. Even though technically that advance parole is not valid, there is a memo from USCIS that allows, from the CBP, that tells that you are allowed to come back into the United States. Now, also we have seen people where people have H-1B and H-4 and who got the green cards while they're outside the country. We told them use the H-1B or H-4 to come into the United States. We had no problem whatsoever at all for them in entering into the United States.
Part has a question. I'm maxing out my H-1B in October 2023. So what, a year, almost 2 years from now, almost a year from now, we're in 2022 now. I've joined a new company today. Do I have enough time to get my perm and I-140 approved before max out? I think you do. I mean, we're seeing right now on the perm side, yes, it's taking a while, but it looks here, Part has got a year and 9 months to get this done, and that's that should be plenty of time. We're telling folks a year.
But I wouldn't use the word plenty of time, Stephen. I would say
I'll get started now.
Yeah. As long as you get started in the month of January, and at least by the early February, first 2 weeks of the February, then you are very proactive on it. That is the best thing. If you delay it though, then sometimes it becomes a problem, Stephen.
Yeah, because we're seeing perm getting done about 10 months.
Why would it take 10 months or 12 months to file a perm? Can you explain?
Yeah, so I mean,
while it you only take 1 week to file the H-1B.
Yeah, our the bane of our perm department's existence, right? So I mean, perm's a multifaceted thing. One, there's lots of regulatory time, how long you got to do recruitment and all that. Multiple steps through the government as well. Prevailing wage determinations are taking a while. You've then got to wrap up all your recruitment and then file your permit, and that's taking a while to get adjudicated. So you've got 2 times that's really sitting with the government that it's backlogged on top of the regulatory, requirements that you as the company as a perm applicant has to go through, and that's where we're seeing the backlog.
Uma Girish has this question. what's the system? How these service centers are acting on the 485? Is it the service centers or is the field offices that have these applications approval though? Mostly it's about mostly it's the field. I'm sorry. Mostly it's the service centers that are approving these cases though. We have seen at least in the first, when October 2020 cases were been filed, starting in June, July, August, we started getting the approvals mostly from the National Benefit Center, where the file numbers start with MSC. We haven't seen initially at all from a Texas Service Center or Nebraska. These are the three places your application will end up in. Lately, I've seen some improvements in the Texas Service Center. Nebraska was always better than Texas. Lately, we have seen some improvement. But one thing is for sure, Stephen, that the amount of cases that we're getting approved from the National Benefit Center is way, way, way higher than the Texas Service Center. Is there any way you can sue the USCIS on this? What happened? You've been suing them.
Yeah, so on the 485 side, it's a little tricky. There's some work throughs that we're going through right now on that. We actually talked about a new theory today, even. But the problem right now is on 485s with delays, like we've done on H-4, L2s, and right now we're doing it on the interim benefits for the green card, the EAD and AP. 485 is discretionary. The USCIS, yes, they're doing it, but that's a discretionary thing in the Immigration Nationality Act. And in order to sue on delays, it has to be a required action of the government. And since it's discretionary, they've been able to argue this is not, there's no jurisdiction. Courts can't rule that there's a delay because it's discretionary, it's not mandatory. And I think, last spring, late summer of last year, we saw about 40 cases where the courts dismissed these cases for lack of jurisdiction. And like I said, we're working through some theories. It's not something we're going to have overnight. Some of them might need to be slow played.
Can you throw out some of the theories? Because you are the litigation director. I get so many of these people. Can you sue the USCIS for the delay, especially in Texas?
Yeah, I mean, it really is going to depend on trying to prove up that there is jurisdiction, and there's some ways we're working around that. We even talked today with my colleague from another law firm about a completely new idea, especially for these that are trying to interfile, to EB2 now that filed with EB3, to at least get them to acknowledge that. And that's, kind of in its infancy. We're not there yet, but it's something we can get them to at least acknowledge the EB2 so that way it can continue. So stay tuned. We're very active on social media. When we have some ideas, we'll let you all know.
I have this question. I really don't have an answer for this, Stephen. Maybe I need your help in it. Can I do crypto mining on H-1B?
Yeah, I saw that one, and I saw another one I was curious about. Crypto mining, I don't know a lot about the cryptocurrency side of it, but if you're doing it for yourself and, just you, I don't know if I would consider that work. But if you're working for a organization, I think it would be. And I just don't know enough about the crypto sector to be educated enough on how to answer that.
What I was being told is that they have to write some program in the software or to do something in there, and the computer keeps running and depositing the money into your account.
Yeah, so I think that might be closer to working.
Yeah.
What about gambling? That's another question.
Gambling seems to be fine. I don't see a problem with it.
Yeah, so if you're a good blackjack player, you can.
Yeah, you're good. As long as you don't make it as a profession, though. If you just go to Las Vegas and you play, you win the money, you pay the taxes, you're good. Absolutely no problem with it. Crypto mining, I want to stay away from it.
The one thing to be cautious of with the gambling, I would just make sure, especially if you're doing anything like sports gambling or anything, it's legal in your state. Not every state has it, and even though you can get access to it, especially from an immigration side, I'd be very cautious. Even though there's workarounds, right, to do it, be cautious that you're not violating state law that may come back to bite you.
Thank you. That's very good. But if you want to go to Las Vegas, you want to gamble, guys, that's perfectly fine. As far as the legality is concerned, it's perfectly fine. I mean, you go into places, but online thing is where Stephen is a bit worried about.
One more that we'd had on this, is it work, is it not? H-1B holder doing YouTube videos for money.
For if it's an entertainment purposes though, it's perfectly fine. But if it's something to make money, I mean, if I want to just I want a restaurant, I want to review it. This is my option, this is my passion. I want to review the movies, it's my passion. Then it's fine. I mean, my passion is running. I even go, I even train,
Yeah, for
sometimes
marathons.
for marathons, yeah. But that's my passion. I don't actually get money from it.
Right.
So that's perfectly okay. But if you're doing it as a profession to make money, though, that's not allowed. If you're doing it as a passion, that's perfectly fine, not for making money.
One question I've seen, and I wanted to address: have you seen cases where the primary applicant got the 485 EAD, and the spouse is still waiting for the 485 EAD after 4 months? Have we seen that? I have. We actually just we see it quite a bit. I actually sued on a very similar case just like this a couple months ago, where the primary spouse got approved and they figured, you know what, it's coming, mine's coming. And they waited 3 months and decided to take some action. We got a positive result on that, and we can definitely emphasize that. But we are seeing more instances where the 485 is being decoupled from the primary and the derivative spouse. The EAD application, the AP application that are being decoupled from the primary spouse. So yes, it is happening. It's not all of the cases. I'd probably say 25-30% of the time we're seeing it decoupled, but it is something that can happen.
Sirisha has this question. Her perm got approved. She applied I-140 in premium processing. Can she use the I-140 receipt notice to file and include the 485J supplement and file? Can she include the I-140 receipt notice and file the 485? The answer is yes. You can include the I-140 receipt notice, but you should also include the 485J supplement if you're doing. However, though, Shirisha, when I look into the stats of people who are filing with the pending I-140 as compared to the I-140 approved I-140, let me tell you one thing, Sirisha. The approved I-140 people are getting the green cards way, way faster than those people who are filing along with the 485 I-140 or filing with the I-140 receipt instead of approval. So in your case, I would rather stay because your priority date is December 2011. It's not going anywhere. So I would rather wait until the I-140 is approved so that your green card will be approved faster. I mean, I've seen these people not even approving the EADs. They're getting some of the cases of the getting approved green card.
Some message you about that earlier this week, a situation like that.
Yeah, in fact, today we got some of them that were filed in October. 3 of them got approved last week that were filed in October. So these are all the people if we had already had I-140 approval. So yeah, in your case, you can file it, but strategically, I would avoid until you get an I-140 approved.
And I mean, the silly thing to think about with these downgrades, especially the reason we're seeing the long processing times is there's really two lines you have to go through. You've got to go through that I-140 line to get adjudicated. I know Ryan, who does our I-140s in our office, sees issues with the premium upgrades with those. So you got to wait through that I-140 line, and then you're in the 485 line once that I-140 is approved. So it's two lines.
Since the application goes together, Stephen, there are some officers in the USCIS that are good, that adjudicate the 485. There are some officers that adjudicate the I-140. But there are not many officers that can adjudicate both the things together.
Right, so we got to go.
And that's where the whole problem is causing. And we were not prepared for it. Had we known that the priority date is coming, we would have filed the EB3 downgrade long time ago, got everything approved and make it ready though. And that's the reason why we suggested to a lot of people that if your priority date is until 2018, get the EB3 approval, EB2 approval and make it ready so that you can file it because you will avoid this problem of using one officer for both the things, which are very less number of officers. So Sirisha, I would wait until I-140 is approved because you're December 2011, your priority date is current in February also for you.
Nagaraj on YouTube asked, can an H-4 with an EAD do a banking job? Absolutely. Once you have that H-4 EAD, you can do any lawful job at all, whether you want to go work at a library, whether you want to go, work at a restaurant.
Can they do Amway? Can they do Mary Kay?
Absolutely. I mean, if you want to go work for NASA, you want to go work for Mary Kay, any lawful job you can do as an H-4 EAD holder. I was question here on YouTube. I was on H-1B in the U.S. for 1 year, so worked on the H-1B. Went back to India, joined another employer. The first employer revoked the H-1B. Can I still use my remaining 5 years?
Absolutely.
Yeah.
And there's a lot of questions that come out. Can it be done after 4 or 5 years, after 6 years, after 7 years? In your lifetime, you can do it.
Yeah.
But you will only be limited for the 5 years, though, not the entire 6 years.
Right. Yeah. So in 2017, all these regulations change. If you've ever been counted against the H-1B cap, you're always going to be counted unless there's issues with the original case, fraud, willful misrepresentation. With the first filing, you're always going to be counted against the cap. So absolutely.
Can H-1B visa holders post YouTube videos and get money for views? No, that's not legal unless you're working for a company that allows you to do it and it is part of your job description or related to job description. No, because that you're working there. Remember, it's not an investment. It's not like you go invest into the crowd fund in some real estate and you're making money. That's perfectly okay. Here, you're actively involved in posting the videos, acting for the videos, making the videos. That we consider it as working, though.
Yeah, if you're just going to make YouTube videos, you like to talk about different recipes you're making, and you're just posting them up there so people can watch, you're not making money, no issues with that. It's when you start revenue generating that can cause some questions.
I'm a chemical engineer with PhD. I'm working in my own field. However, I'm planning to study finance. Can I do that? Oh, Ashish, you're studying too much. Definitely, absolutely. I mean, Ashish, I've seen so many people. I have seen people who have masters of engineering and then they started all over again and become a doctor. It happens. I've had one gynecologist when I was taking the bar exam. I was like, what are you doing? It's like, that's okay. I want to become a lawyer. That's my option. My parents pushed me to become a doctor. I never want to be a doctor, but I want to be a lawyer. Okay, that's fine. You can do that too. Even though you're a non-immigrant visa, yes, you can study. On H-1B also, if you want to do study part-time, you can do it. And if you want to do full-time job and do full-time study also, that's allowed too. If you want to move to F-1, that's also allowed too. You're perfectly allowed to study on H-1B as long as you are keeping the job and you're maintaining the status. In addition to that, if you want to go to school, you can go to school.
Question on YouTube, and we didn't address it today, but it's been a common topic. Build Back Better. Is it dead? Immigration side of it. What do you? I mean, my thought is, I know right now, Congress has decided to focus on other things, especially voting rights first. That's where all their political right, yeah. That's where all they're putting their political capital right now. I don't know if Build Back Better is going to come back.
I think so. We will have a better chance of probably fighting on per country limit, Stephen. That's one thing. I think so. We'll be better off fighting on not counting the family members in the 140,000 green cards, though, which we're going to start the campaign probably in the next 2 weeks. Rather than fighting on the build back better, I would rather focus on these things because in the INA section, though, when they are allocated the 140,000 green cards, it doesn't say that they have to count the family members. It doesn't say that. In the H-1B, there are 65,000 and 20,000 a master's quota. They don't count the family members. Why are they counting in the 140,000 green cards? But this is not something we can go to court. We can request the administration to do it. At this point of time, Build Back America has too many other things. Out of the 800 or 900 or some pages, though, we're only like 7, 8 pages there. We are not that important there. There are many other things. So I would rather focus on these two things, taking the per country limit off and also on not counting the family members. If we don't count the family members, it goes off 140,000 to about 300,000 green cards. That will be enough for us, though. I would rather use my energy in fighting it. And starting from next week, we're going to campaign for that. We're going to draft a letter and put it for the people to start writing the letters.
So when EB3 retrogress interfile and EB2 are suggest refile fresh. I'm going to highly recommend. Rahul Emily did a 10-minute video on this on our YouTube channel. There's a lot of things to consider on both sides. Both sides are with merit. I think if you ask 100 different immigration lawyers, you're probably going to get 100 different answers
Yeah.
on a
It's now clear after you watch the 10-minute video though. If you still have a doubt though, I will tell you a solution what to do. Go to your spouse, give the spouse a coin, let your spouse spin the coin, heads, interfiling, tails, refiling. And guess what? If your spouse proves to be correct, you should give the credit to me because I suggested your spouse's name there. Now, if if he or she turns out to be wrong, the blame should go to your spouse.
question from
I'm
Saran.
just checking.
Can we file litigation for EADAP renewal delay if processing time is greater than 6 months? We have done a lot of these interim benefit cases. We've done a couple of the renewals. Very few of the renewal cases because they're getting approved, people filing early. But yeah, it is available. We have some time. We're looking at these cases being pending for at least 6 months, especially. But yeah, there is options on those. Schedule, set a call with me and we can talk about whether it fits for you or not.
Chetan has this good question. Can we start working on 485 EAD? I-140 is still not approved. Legally speaking about Chetan, you are allowed to work on EAD. But as a tactical point of view, though, I would strictly recommend it to get the I-140 approval, though. You can do premium processing of I-140. That may be the best solution. But legally speaking, you can.
Can a TN holder file for a green card?
Can a
TN holder.
They need to check with the lawyer, though. Here is the problem, though. When it comes to the renewal of the TN, they will look into the aspect if you have filed for the green card, they may deny your TN visa. It may be strategically better for these people to move on to the H-1B and start the journey towards the green card process, though. Chandana Yuruwaka from YouTube has a question. My I-140 got approved, but it's just been approved 30 days ago. Can I change the job now or do I need to wait for 180 days have been passed? Chandana, it's only 180 days from the time the 485 has been filed. Once the I-140 is approved and it's been more than 180 days that your 485 has been filed, you do not have to wait for 180 days after your I-140 is approved. You can change now.
Jash from YouTube, when can we expect H-4 EAD premium processing? It's already late for implementation. Yeah. Couple things to keep in mind. We don't have a timetable. It did move to the budgetary office. Because they put a date on a regulation isn't mandatory. The example I always like to use in our office is that, for years, the Trump administration had removing the H-4 EAD on the regulatory agenda. Nothing came of that. Yes, I know it'd be great for them. It'd be great revenue for USCIS, save a lot of jobs, but they're not bound by the regulatory agenda. It's kind of aspirational. We haven't gotten any updates on the premium processing. We've asked for updates, from the U.S. Attorney, and not gotten anything on it. I have an approved I-129 H-1B extension. My I-94 expires April 2022. Do I need to exit the country to have new I-94 enforced? No. So this comes up a lot, right? The electronic I-94 that you see online is only updated when you travel. So if you came in and your I-94 expires April 2022 and you've got an extension, the bottom of that extension will have a tearaway piece on the approval that will show your new I-94 date that should be extended by now. So take a look at that. That's your new I-94 date.
My child is locked under CSPA, but I'm about to lose the job within 180 days. What are the options? Will you lose it? I would strongly recommend that you contact an immigration lawyer. There are ways around it. It's better that you take a note of those things. People are asking with regards to the Texas Service Center that what you have seen the approvals. Which month dates have you seen the approvals that were filed in Texas Service Center? When I look into the Immigration Girl, which we publish the stats every week, though, these are all filed most of them are filed in October of 2020. There are some cases that we filed in February of 2021 also. But most of the cases that we see that have been approved by the Texas Service Center that were filed in Texas, that had a SRC, were being filed in October, and some of them were being filed in the month of November. But we're going to update every week, guys. I want you to watch the Immigration Girl, and we're going to repeat that every week. The updates will come in on which service center is acting what.
Question on YouTube. Is it true that we cannot apply for an H-1B extension if the priority date is current? No, absolutely not true. Now, there is something to consider here. If your final action date is current, you can only request a 1-year extension under the AC 21 extension provisions. If it's just your filing date that's current, you can do the 3-year request, but if your final action date, you're only going to get a 1-year approval, but you can keep filing that. If your final action date after that year is current and you don't have your green card, you can file again as well. So no, you can absolutely file for extensions. It's just a question of how many years can you get on the approval.
A lot of people are asking interfiling or refiling. It's going to be tough, guys. We want you to watch the video. There's no clear answer. Can I rent my car on L-1B visa? No, I don't think so. Here is one of the reasons when I rent the car, I need to do a lot of servicing to the car. What do you think?
Yeah, I agree. I mean, you've got to put it up, on websites to rent it out. You've got to. Now, if I'm just giving it to you as a friend, I don't think there's any issues.
Yeah.
But
now, it's quite different when you are renting a house, though, because there's not much work involved in it. But when you're renting a car, it's a day-to-day business. A lot of work is involved in it. I would strictly stay away from it. Now, a lot of these things are the gray area, guys. I mean, right now, things may look fine, but what if tomorrow they say, boom, we're going to deny it because you rented the car? I don't think so. It's what I at this point of time, I will stay away. But as far as the house rental is concerned, though, we have had this issue many times. It's addressed. We never had any problem. That was fine.
question from YouTube. My friend is transferring H-1 visa to another employer, maxing out in a year and a half. Passport expires in 12 months. Will she get the I-797 approved beyond the expiration date? Absolutely. So this requirement that your passport is valid and getting the shorter approvals only happens when you enter the country. CBP, Customs and Border Patrol, is only going to issue the I-94 when you travel until your passport expires. But when you're filing with USCIS, and I've done this plenty of times where someone's passport expires the next month, within 6 months, they're still able to get that full year and a half here because of the max out or 3 or whatever you're requesting that you qualify for. No issues there.
Srinivas Mahesh has an interesting proposal to his wife. He went to his wife and asked about the interfiling or refiling, but he didn't follow my direction. He asked his wife what to do, and she said, do what Mr. Reddy says. I didn't say that to you. I said give a coin to your wife and let her toss it. You did not follow my direction, Srinivas.
You and I are both married. We'd like it. The wives would like it if they can blame us for making the wrong decision, right?
Yeah. I didn't suggest her to give an idea. Just tell her to toss it. That's it. And heads and tails will call it.
Question here. I think this is a good one. How much time do I have to apply for a 485? Can I delay it because I have to go to India for a few years? Can I get an H-1 after a few years?
Oh, come on. I mean, you prayed for God for 5 years now. God comes here and you said you want to go to restroom. Just take the boon. Please, there are a lot of negative implications, though. I would strongly suggest that if you're now at this point of time filing the 485 planning to go to India, I would suggest to speak with a lawyer to make sure you know the temporary things, permanent things, long-term things. Some you can file the 485, you can abandon it and you can get it back later on if you want to the priority date. There are a lot of different options that may be available. You may even consider consular processing. That's another thing that you can do. It may take a long time, but you should consider the consular processing option too.
Roger Reddy asked, and I think Rahul and I may have a different opinion on this. I think if you ask 15 lawyers on it, they might. I have my 485 EAD. Is it possible to maintain my H-1B while working on part-time using the green card EAD?
Here is the thing, though. Once you use the EAD, though, practically you're married to the adjustment of status. Because on H-1B, you could not be working with company A and company B unless you have H-1B with 2 companies. Once you have to use EAD, technically you're considered to be EAD. The question that pops up is that am I under obligation to inform the company A who is an H-1B to use the EAD? If I don't inform, will there be any negative consequences? As far as the negative consequences are concerned, if you don't inform the company about the EAD use, we don't see any negative consequences on immigration though. But as such, you are considered to be married to the adjustment of status. There are ways to get divorced from that, from the EAD. I mean, you can always go to Mexico, come back on H-1B, show the I-797, you're on H-1B.
And I think from an employer perspective, it shouldn't matter that much. You have that authorization to work. With that green card EAD, you can work any job. So if you're working for company A and company B, they, company A is time to renew your H-1B, you just tell them, hey, I got a green card EAD, and they're going to do I-9 off of that instead of your H-1B. So it shouldn't have any impact on it if you do decide to get married to that EAD.
Gadgets World from YouTube has this question: does restraining order divorce impact 485 green card application, or any precautions to consider? If there is no criminal case, no arrest, nothing is involved in it, we don't see any problem just because a restraining order has been issued against you, though. Now, restraining order is a civil matter, so you do not have to even mention anywhere in the 485 application that the restraining order has been issued, because that's not a criminal matter. In the 485 questions, have you been arrested? Have you been cited? Have you been charged with any crime? The restraining order doesn't come in because it's a civil matter. You are fine. But if there is any criminal things, if case is filed, arrest or anything like that, definitely I would want you to consult a lawyer to make sure everything is going to be okay.
She says, how can I bring my wife to the U.S.? I'm on green card EAD, EB1 485 pending. My employer's lawyer said that it may take a couple of years to get her I-130 approved. Is there an easy procedure? I looked into this today. I was curious. I was talking to someone about I-130s, and they said, I don't think they're taking that long. I looked it up. 5 years.
Yes. There are a couple of things, though. If you have not gotten the green card, though, you may want to consider into moving back into non-immigrant visa. That's one option that they can think of. Since their I-140 is approved, they are still eligible for H-1B even they complete the 6 years. That's one thing they can think about it. Moving back to the non-immigrant status is a very good option. The second option would be that they can file something called following to join. It's called I-824. So when you file an I-824, though, once your green card is approved, they will link your green card, and your spouse can get a green card in India too. Now, sometimes I-824 takes longer time than I-130. You cannot file an I-130 until you get the green card, but you can file the I-824 as soon as you are married. And even if you did not get the green card, you can file the I-824. So first importance that I will give you is to try to move to the non-immigrant visa, get it back. Second is to file an I-824. And once you get the green card, I want you to file an I-130. Now, when the I-130 comes in, Stephen, though, there are different categories of the I-130s, though. Especially if the priority date is current. For example, suppose F2A is current, though, the processing time is less. When it comes to the brothers and sisters, I've seen 10 years also, particularly in California, etc. But most probably it's about 1 year. The total processing is about 2.5 years after he gets a green card. So I want him to do, if he can't get into the non-immigrant visa, though, I want him to file the I-824 and then file an I-130. Do both the things rather than doing one thing. In that case, whichever comes first, he can take the green card.
Kind of ask, I'd like to send an invitation letter for my in-laws to request B2 visas. We're expecting a baby. Is it okay to mention this as a reason?
Why not?
I think that's a perfect reason to visit the U.S. I mean, you're coming in for...
your parents came and helped when you have...
Yeah, my parents came in from Virginia down here to Texas, so that's very common, and I don't think there's going to be any issues with that.
Thank you. I think so we're running out of time. Stephen, do you have anything else?
Oh, no. Feel free to contact us if you have any questions.
You can make an appointment. The link is provided there, guys, with me, Stephen, or anybody else in our office. The link is provided there.